State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney, appearing for the state. Mr. Robinson, are you here?
I am here representing the name, ma'am.
Welcome back to the courtroom, everyone. And trust me, today's case is one you'll want to buckle in for. We're heading straight into Kansas for a legal showdown featuring one of the most persistent courtroom characters, the self-proclaimed sovereign citizen. Now, if you've ever seen one of these individuals argue in court, you already know. Things don't just get unusual, they get philosophical, theatrical, and at times, spectacularly illogical. Our main character today isn't just contesting a speeding ticket. No, he's challenging the very foundation of the legal system itself. According to him, the laws don't apply, the judge has no authority, and he's here on a so-called special appearance to challenge jurisdiction. But there's just one problem. He's using language pulled straight from sovereign citizen internet forums, and he's trying it in front of a judge who has zero interest in playing along.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
Here's the moment where everything starts tilting sideways. Notice how he doesn't simply say, "Yes, I'm here." He says he is, representing the name. This is a classic sovereign citizen tactic where they attempt to separate themselves from their legal identity, believing that the name on government documents is some sort of corporate entity they can distance themselves from. To them, it's like there's a real person and a paper person, and only one of those can be held accountable. Judges have heard this countless times, and it never works. Not once. But it does signal that the judge is about to face not a normal case, but a legal performance piece straight out of YouTube's pseudo-law.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appeared to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is that.
The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph, ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear. Talking again about an administrative agency and tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. The court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, J, beneficiary.
This is where the judge subtly begins dismantling his claims without even fully engaging yet. By pointing out that he can't make a special appearance because he's not a licensed attorney, she's essentially saying, you can't use legal terminology to elevate yourself to a status the law hasn't given you. Sovereign citizens often believe that saying certain phrases unlock special powers, like magic words, in a courtroom. But legal language isn't spell casting. It has meaning, structure, and requirements. The judge is signaling early that she won't be pulled into the fantasy. And when a judge is calm, composed, and sure of the law, that is the worst possible scenario for a sovereign citizen who came prepared with copy and paste internet arguments.
The next page talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K. issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed, end quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records. And he says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days. or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson Tremaine J. without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Revocation of signatures on the final page 7, mentioning that, quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road of the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se. And that was authorized based on the previously referred to 7-page document. It would indicate at the time to the court that Mr. Robinson did want to proceed pro se. So Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
This is one of the most common misunderstandings in cases like this. The idea that if no one was physically injured, there is no crime. But the law doesn't only exist to clean up disasters after they happen, it's designed to prevent them. Speed limits exist because thousands of real tragedies have taught lawmakers what speeds are safe in certain conditions. If we waited until someone was hurt every single time, the legal system would be reactive instead of preventative. What's interesting is how confidently he asserts this logic while ignoring that driving is a regulated privilege, not an unrestricted right. And judges don't debate philosophy, they enforce established law.
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of, including what he offers as a motion for discovery, was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
We're going to proceed with trial. So please put yourself back in front of the camera, follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive need statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case, involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
This part of the transcript is a perfect demonstration of how sovereign citizen language has become so widespread online that judges now instantly recognize the patterns. Terms like beneficiary, natural man, without prejudice, hyphenated names, and colon signatures all stem from fringe interpretations of contract law mixed with conspiracy theories about government identity fraud. The judge isn't angry. She's simply unfazed. When she remarks on not being able to read his signature or interpret his formatting, she's pointing out the fundamental problem. Legal filings must communicate clearly. Adding colons, hyphens, or theatrical declarations doesn't elevate your legal standing. It just signals to the court that you're relying on pseudo-law instead of real law.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the